My car was on track to be repossessed. I had a mortgage. I was also paying rent at an apartment. The numbers started to get real crazy and it just became overwhelming. So most people go to work to pay their debt.
That's basically the modern day slavery right there. In a nutshell, you got to change the way you look at money and understand that this is all worthless.
They don't want you to be sovereign. They're not going to teach you how to get to their level because they make more or benefit more from you when you don't know. And they don't want you to think outside the box or critically think about your life. They want you to be more of a drone and think like them or think like how they want you to think.
Before we do anything else, we want to state this is not legal advice. This video is for entertainment purposes only. And anything that we discuss in this video, we implore everyone to do their own research because we're all responsible for our own education. All right, perfect. So Nick, I was reading your Instagram bio and it says that you do wealth tactics, you're a capital access coach, and you teach consumer law completely free. I want to start at the beginning because I believe that whatever it is that we struggle with usually reveals our true purpose. So what was your introduction into consumer law and why do you think it was imperative for you to not only learn this, but to teach it for free?
My introduction into consumer law, I mean, that's a great question. I mean, I had the same problems that we all had. My car was on track to be repossessed. I had a mortgage and I was also paying rent at an apartment. And the reason why I had those two payments was because I was attempting to rent out my home. But, I was brand new to the renting space, so I was still learning, procrastinated a couple months, got behind on my mortgage, and the numbers started to get real crazy. I had heard about remittance through a business partner of mine the year prior, but I didn't like fully understand like what it meant. I started watching videos about coupon remittance, and that kind of just opened up the floodgate about what was happening behind the scenes when it came to debts, when it came to bills. So I had a very surface level understanding, but I didn't start diving into it seriously until I actually needed it. When I got behind on my mortgage, when I got behind on my car payment, I think I was paying for two cars.
Oh, wow.
I was paying for my car, I was paying for my girlfriend's car at the time. I was paying rent, I was paying a mortgage, and it just became overwhelming. And I was also growing a business too. I figured if I tap into consumer law, if I can figure out how to discharge a debt and I can figure out how to put myself in a position to communicate with debt collectors and not have to worry about paying or being so fixated on making sure the debt was paid, then I will have a little bit more freedom. And obviously, it didn't go like exactly how I expected it. I've had failures. The mortgage company attempted to foreclose on the house. Thank God they haven't foreclosed on the house. I was able to do just enough. But it wasn't perfect starting out. I got excited about a couple videos, which a lot of people may do with my videos, get excited and just start taking action without fully understanding it. And that was me in the beginning. Probably, no, this is like 2022 going into 2023 was when I really started going through those financial troubles. And I'll tell you, it wasn't until like 2024 where I fully started to understand it and going into 2025 where I really had confidence and found the legal merit behind what I was doing. It was all like, a theory to me. It seemed mythical even while I was doing it. And I've gotten some success, but when I really look back, like that was just luck. I didn't even take him through the full process. May have sent the debt validation letter here. Was able to represent myself in court for some cases. I went to court for my HOA company. My mortgage company never even gotten a chance to take me to court. I was even in the position where they was about to auction off my house, and the letter I sent them literally stopped the auction. And to this day, they haven't been able to auction off the house. Still have the property in my name, so I'm blessed and grateful for that. But haven't had to pay it this entire time. Still have ownership over the house. Of course, that first vehicle got repossessed, but my second vehicle, I challenged the debt and was able to stop the debt collectors. That vehicle ended up getting totaled. So, I mean,
So the one
Um,
thing I really am hearing right now is that everything that you've done, you're self-educated and you learn through your own personal experience. And I think that's the reason why I really like all of your content, because I could tell you were someone who went through the process and you learned exactly how to do it. Um, and I don't think that enough people, especially on YouTube, when they're trying to teach others, are very vocal about exactly what it takes to actually do all of these things. Like you said, you didn't fully understand it, but as time went on, you started to grasp this information. And I think that, like, first of all, your story is very inspirational, and I really do appreciate you sharing that with us. And right now, like I was telling you prior, I released a video where I was talking about infinite money and how you can actually use discharge debt in order to repair your credit, among other things. But someone put me onto one of your videos, and that's exactly how I got to you. So for everyone that's watching this video right now, there's something that you could look up called the Emergency Banking Act of 1933. For everyone, again, I'll put a link in the description so you guys can look this stuff up. But it's also been called HJR 192, which stands for House Joint Resolution 192. Now, this was eventually codified into U.S. law as a statute. It's not a law, and it's not in the sense of common law. It is commercial law, because everything that we're dealing with, we're talking about commerce. But this thing basically took away the ability to pay back debts, and you're not able to do that with gold or silver anymore. And as for, like, what I even learned from your content, and I mentioned in my video, Black's Law Dictionary almost says the exact same thing. A lot of people don't know this, but we don't embrace notes, bonds, or evidence of debt. And then the dollar is just a promissory note. We call it a note. It's short for promissory note, and it's a type of negotiable instrument. And if we look at the UCC, Uniform Commercial Code, then it defines a negotiable instrument as, such. But basically, I did all this stuff. I talked about it, went through this entire thing about how to remedy this situation. They allow you to discharge debt, which then literally, when I was like, okay, how am I going to explain this? Came to your video, everything laid out perfectly, clearly. I was like, well, damn, I don't even need to do this. And it's like everything is here. And it was like and it was explained in a way where I feel like I have a hard time trying to, like, people think I'm really good at it, but I actually have to do a lot of work to try to explain ideas to people. I want to see if basically we could break this down in a very, very simple way.
okay.
Okay.
I'll
I,
try to make it as simple as
Yeah,
possible.
I know. And I know it's not easy, because it's like, even when I was trying to do it, I'm like, this is not the easiest thing to explain. But when we get a statement in the mail, we get like a bill or something like that. There's a number on there. And
Mhm.
what is that number exactly? And I guess, where would the average person find this?
Okay, so I mean, there's plethora of numbers on the statement.
Mm,
You understand me? It's really thinking about what they are delivering to you, which is a bond with a coupon attached to it. Now, for those of you guys that are, understand private banking or understand just banking in general, we know that bonds are securities, and securities are money to the bank, financial assets to the bank. So what they do is they send you a bond with a coupon attached to it. And when you look at the definition of a coupon is a interest check. Okay. It's not
mm.
something that you would pay, it's a check. And when you look at it, it looks like a check. Am I right or am I right?
No, no, you were definitely right.
You know what I mean?
Yeah, no, and so and I thought that was crazy, because it's like, okay, we're receiving an instrument, which is a coupon that we can now turn into a check. Um, why are we getting this in the first place?
Because because our rights, our God-given rights is to have those essential services. If I did a video on utility bills, and I learned that the utility companies we are under the assumption that they are prepaying for the utilities, loaning us the utilities, and we're paying it back. But the reality is that they're actually getting government bonds and revenue bonds that is already paying for the service. Why is that? Because having this service is a God-given right. Okay. This is just supreme law that goes above commercial law. Okay. And obviously, like, one may say, okay, well, if they are delivering the service or was prepaid or whatever the case may be, like, I should pay them back. But what if that government bond was in place because we need to have these services in order to survive? But what happened was the fraudulent part is the fact that they are not informing us on this. Okay. If you say that you're prepaying for something and you are loaning us an energy source that we have to pay back because you paid for the source yourself, absolutely, we should pay that back. But what if that wasn't the case? And it's now not even really a conversation about you owing somebody. It's more about the conversation of the contract itself. Okay. What did you contract to? Debt is literally just a contract. Okay. An agreement between two parties. And these parties have to, and I don't want to dive too deep, but long story short, there must be value and consideration. Okay. Our value is what we sign off on, which our signature monetizes that loan agreement or monetizes if we're talking about a utility bill. When we sign off on that agreement, that becomes something that they can make money off of in the first place or afford them the ability to be able to get these revenue bonds. Okay. But we are under the assumption that they are getting it through their own sources. They are using their own money. So that's why we pay them back. But what that coupon is more of a interest check, and it's a surplus of the money that was released to them that they are giving back to us to then credit the account. Okay, so I'll just kind of pause there and just we'll compound the conversation as we go.
Okay, yeah, because you actually hit a lot of points on there, and that number that we're looking at, that is the remittance number, right? That the one that we normally see on the bills, like our utility bills or things like that.
So I mean, there's the account number, series designation number that could be on there. But when you look at a coupon, I mean, just like any other check, it has the account number and the routing number. But this is only an indication that it is connected to an account. A lot of times, and I made a video about the number on the remittance. Um, and really, that was just to drive the attention towards the number. But what I actually broke down towards the end of the video is that the number doesn't really like help, is not gonna like help you discharge the debt. It's only an indication that it is an instrument. It's an indication that it is something that is a security. It's an indication that the bank makes money on it. Okay, so that indication gives you the lets you know that this is something that you can challenge them on. One of the questions that you can ask on the premise of a contract is, where is the money coming from? Where is the money going? Okay. And uh part of that is like part of that is more of I'll just say it's just more of an indication that it's being monetized when you see that number. Okay. So
Okay.
that's what I'll say. So it's less about the number, it's more about the questions that you will ask because that number is attached to it. There's also a lot of people talk about a QSIP number, and again, the QSIP number is an identifying number for a security. It's just an identifying number, but that there lets you know that it's money, and they'll make you think that you can't accept it for value, you can't use it, or that they are not using it. And this is what is a direct violation of any type of lending, any type of contract, because it requires full disclosure.
And okay, yeah. And I remember in the video you talked about how contracts are supposed to include full disclosure, but why is that such a big deal when billing statements don't clearly explain everything, especially when it comes to debt? Well, first of all, we don't even fully acknowledge the fact that this is a contract because we're not aware that it is a contract. So, what is the repercussions when someone, I guess, gives me a contract that I don't fully understand?
It becomes unenforceable. It
Yeah,
becomes null
yeah.
and void. So that's the point. Like when it comes to because if one says we are loaning you something, this is what you're contracted to, loaning you something and you paying back what we loaned. But what if the reality was that you never loaned me money? What if the reality was that my you just exchanged what I signed for the money, or you was able to create that money out of thin air because of me? If this was a real full disclosure contract, you would just disclose that to me that, hey, we are working together. Hey, we are business partners. I'm not loaning you anything. You are signing off on a contract or on a promissory note on a security, and I'm going to take this security and exchange it with the Federal Reserve. Now, all of this is already broken down in modern money mechanics. So, if one wanted to actually look up what is happening when it comes to loans or how money is created. It's in modern money mechanics. So, it's not a secret. They just don't tell people who don't do the they're not going to tell you because they are able to make extra money on top. And it's not that the bond and the coupon is the contract. It's more about, when you originally got in the contract, this should have been disclosed to you that when we're sending you bonds and coupons that you can accept for value because it does have a value. You don't have to send us this here. You don't have to send us this dollar. Okay. This is not what makes us money. What makes us money is that coupon. What allows us to participate in commerce is your original loan agreement, not this dollar, because this dollar is just a debt certificate.
and
Okay.
and to see most people like, and that's normal because it's not like anyone taught us this at all, but most people, we look at a bill, because I've done it, of course, and we just assume that it's a request that we're paying back something that we owe. But what we're not told is that the payment coupon at the bottom might actually be a negotiable instrument, but no one ever explained that to me. And that now this legal document can actually route financial value
Mm-hmm.
and be securitized. And no
Yeah.
one ever told me that. I never understood that. And I'm entering into this financial transaction without knowing the full scope of the agreement. And I think that's where a lot of people get lost, because there's no way for like us to actually comprehend this information unless someone like yourself is making content that actually covers this. And we just know so little about this. So in your video, I know that you touched on the idea that these numbers, they often don't actually tie back to the original lender.
Mm-hmm.
Where are they actually going if they don't, like, if I get a bill for my power, I live in Nevada, I'm assuming if I pay it, it's going to Nevada Energy. What's the significance of it actually not going to Nevada Energy but going somewhere else?
So it's not that when you don't pay, like when you pay it, it doesn't go to them. Of course, it goes to them.
Mm-hmm.
You know, that's where they're double dipping. The question is more of, did you guys already get paid? Because there's a thing called double recovery, double collection, where if you've already been, if a contract or a debt has already been settled, then you can't come after the person for the debt, or the obligation is nullified if it's already been paid, whether it was from you or whether it was from somebody else. Okay. If it was settled, what would be the reason for you to come after me? And this is double recovery or double collection, which is illegal. This is why debt collectors are so easy to challenge, because they just buy your information. They're not actually buying the obligation per se. They're just buying your information and saying, hey, you didn't pay this person, so you have to pay us. But before they sell it to a debt collector, they get paid through insurance. They get paid through filing a 1099-C and charging off the debt. When your debt is charged off, that means they filed the 1099-C and the IRS discharged the obligation. Uh, they also get paid through securitization, where they sell your security to Wall Street or investors, mortgage back as a mortgage backed security, or something that is monetizable. An investor buys it for whatever reason. We're still figuring out what they use it for, but is more of that they are getting paid up front, and they want to make extra money by making you think that that bond and coupon is a bill. But even when you look at the bill, if it's something that you owe, it should have a negative number on there. Okay? So,
Now, legally speaking, because I guess that's where we're going now. I know you're familiar with UCC 3-603, and that's the idea of tender and discharge. And when it comes to that, what happens if they refuse my tender of payment? Like if I try to reroute the value back to me so that I can kind of wipe out this like balance. What happens if they refuse?
if they refuse, then it is discharged according to UCC 3-603. And the refusal, when it comes to a contract, there is multiple foundations of a contract. There is offer and there's acceptance. When you send a negotiable instrument or a tender, okay, if you pull up the definition of tender in law.cornell.edu, the definition of tender is to unconditionally offer money or performance to meet an obligation. When you tender something, you are unconditionally offering money or unconditionally offering a performance to meet an obligation. So now you have sent the offer, and so the next thing that they must do is either accept it or reject it. But when it's unconditional, that means under no conditions, you can either accept this or reject it. There is no counter offer. So they'll do two things. They can either accept it or they can reject it. But the law says that your rejection or your refusal means discharge. So what do? They don't do anything at all. They ignore you. They don't respond back. And that, under UCC 3-505, I believe, talks about what dishonor is.
For everyone. Again, all of these, I'm going to try to list all of these, but you definitely want to be able to look up all this information. Don't take our word for it. You can Google this stuff and look it up yourself, read it, interpret it. If you don't understand it, copy, paste it, put it in the chat GPT, have it interpret it for you. Whatever the case may be, even listening to this, and while this information is amazing, to actually act on it in a court of law is a totally different thing. You have to be able to understand this information.
Yeah,
So
and they're going to expose you if you and this is why, back to the point of like just like breaking down steps for people, but also at the same time talking about the education or the overstanding of the information. You need both, okay? But the thing is when you fully understand the information, the steps come easier because I explain the steps to people. I can say, hey, first thing you do is when they send a letter, and when you send your notice of tender, if they do not respond, you send a fault and dishonor letter, pretty much giving them an opportunity to cure and letting them know that they are at fault. You have dishonored me. You didn't even send me a refusal or an acceptance. You didn't even send it back. I gave you clear instructions in my letter that if you decide to dishonor this or you decide to ignore or refuse it, then according to UCC 3-603, the obligation is discharged. I said that in my previous letter. And the only reason I was able to say that and be confident in that is because I understand the law. And the law told me to say this, okay? But then also at the same time, in that fault and dishonor letter, I'm giving you an opportunity to cure. So I'm moving in good faith, which is also talks about evidence of dishonor, presentments, understanding contract law. So now a fault and dishonor. I'm giving you that second opportunity. But then if I gave you two opportunities to respond and you didn't respond, now I'm going to have you default and I'm going to send you a default notice, laying out all the statement of facts, laying out exactly how you have dishonored me, how you refused me, the legal merit behind everything, and how now you have to adhere to my demands because you default. And then after that, you would take that evidence into court. Okay. I can break that down right now. And to some people who really research it, they'll say, damn, he just gave me the whole blueprint just now. But then there's other people who will say, well, we'll still ask questions about that. And I just told them it. And the reason why is because they don't understand the law. They didn't read it themselves, they didn't review it. So it's super important for you to educate yourself even after you watch these videos, because a lot of times people get excited because they just heard it and they get motivated. But I don't want you guys to get motivated. I want you guys to build the discipline to actually research the information yourself, become comfortable with the information. Because if you go in court, yes, you may do all the steps properly, but if you're unable to explain it or even persuade a judge to say, okay, this person knows what he's talking about, we can't take advantage of him, then they're going to take advantage of you. And they're going to go and say, well, you agreed to pay. And then what is your argument of that? A presentment, when you send a presentment under UCC 3-501, it says presentment is a demand. I'm not asking for permission, I'm demanding. So I just created a contract by sending you a presentment. Okay. And your performance is you providing whatever it is that I asked for, whether it's to let me know whether you accept or reject it, whether it's to return the check back if you decide to reject it, or whether it was for me to ask you about certain disclosures about the contract. I created a contract within itself by sending you a presentment of the demands that I, by law, can do.
And
If you don't do it, now forget what I owe you. You just nullified that contract itself because because conditional acceptance goes like this. I will pay. I'm not refusing to pay. But if you can prove X, Y, and Z, I'll conditionally accept this offer if you can prove X, Y, and Z. So if you do want your payment, and if you are moving in honor, and if this contract follows contract law, the UCC, the USC, then you should be able to provide that stuff to me.
my takeaway from this is that refusal or silence does not protect them. And it can actually trigger a discharge and then open up the doors for legal remedy, I guess, at that point. It only works if you've actually done your part lawfully and correctly, which is why knowing this process is just as important as taking action.
Yes.
Okay.
Yes. And that process being the administrative process that I explained about notice, fault and dishonor, and default.
Okay, I'm gonna try to like go through the process and you could tell me if I'm doing it wrong. But let's try to break this down into something practical. And if
Mhm.
someone wanted to use a remittance coupon to discharge debt, for the actual steps that they would need to take, I would say the first step is realizing that the coupon isn't like a throwaway slip. It's a negotiable instrument. And when used properly, it can serve as a lawful offer of payment.
Mhm.
But the process has to be done legally and strategically. Step one, I would identify the actual remittance routing number. I can Could I take a look at a billing statement or a coupon or and actually get this information to find it on every bill?
Yes. That's I mean, that's just like you already know it's a coupon, you
Yeah.
know. So it that I mean, understanding it's a coupon is the first step. Um is I would say the first step is endorsing that.
Endorsing. Okay. And then for endorsing, that's me signing it with my name.
31 CFR 328.5 and 31 CFR 328.6 breaks down what forms of endorsements is.
Okay.
And on 328, it breaks down like when people talk about the stamp or accepting for value or, for presentation, that's in 31 CFR 328.5. And then 31 CFR 328.6 breaks down how you should endorse it. But the what the understanding part is that you're creating a unconditional offer.
And he gave you exactly where to find this. I'll link it in the description and people can read it. If I'm preparing my tender of payment package, this is where paperwork comes in. I need the endorsed coupon. I need a tender of payment letter explaining exactly what I'm doing, a conditional acceptance, and then I also need sworn affidavit of truth. And all of this is clearly written. And I think you actually mentioned the so I know it's UCC 3-603, 12 USC 411, and I feel like I'm probably missing one.
12 USC 4-11 talks about, I think, the ability to get to lawful money or you can redeem lawful money on demand by the Treasury Department. It also breaks down it breaks down what Federal Reserve notes are and how banks exchange and get Federal Reserve notes from the Federal Reserve Bank. Um, So the fact that you can redeem lawful money, but you actually can't, is why this will work. You know,
Right.
uh,
Because they won't give me the money, but they'll just zero out the
zero
balance.
out credit, use the coupon because the coupon is also a security. Okay, it's no different from the dollar, which is what they'll say you must pay in a dollar. But that's
But you can't pay debt with a debt. That's like that doesn't it doesn't really like that's like fighting fire with fire. It doesn't really do anything.
all this does is really just record that there is a debt. And the United States runs on debt.
Yep.
The main reason why the United States is in business is because they're able to, create and incur debt. The debt leads people to exchange their labor to pay the debt back. So the true value is the labor, you know, and our attention to debt.
I
So now people can
that's a
come
gem. I'm
in
sorry. Can you say that again? The true value is the what?
is the labor and the time
Yeah.
and attention to debt. So just thinking about it, so most people go to work to pay their debt, you know, if you didn't have a debt to pay, would you work at wherever you work? You'll probably be doing what it is that you want to do, you know? Uh, so when you are spending your time, labor, and attention onto something, that's true control, you know? If you're constantly thinking about a debt that you have to pay, and the only way that you can pay the debt is by going to work and working 8 hours, now that affords the opportunity for businesses to come to the United States and use your labor, you
And
know?
that's basically to me that's the modern day slavery right there in a nutshell. But that takes it like that's something where a lot of people's mentality has to you got to change the way you look at money and understand that this is all worthless. It's a crazy thing, but I'm gonna get back to that because I definitely want to come back and approach that at the end because I think that's a great way to get people's mindset to shift. Because I want to definitely come back to that. Um, so now that I have my payment package prepared, how should I send this? Do I send it certified mail? Should I drop it off in a mailbox, or how would I deliver this?
Uh, so at the very basic, cheapest level, certified.
Okay.
Certified gives you the record that you sent it. But there are some people that would send it registered because registered insures it. They also say that if you send a security registered, then if you have a security or you're sending a security, then you want to send it registered so that it can be insured. Also, it's not in a regular envelope. They put it in a box. I haven't particularly seen it. I've always sent things certified. I've sent things registered. The thing is you how you send it. You just got to have record that you sent it, and and this is not mandatory for every single piece of communication, but notarizing it too. And you can notarize everything at the end. Like if you take them through a private administrative process and you get to the last letter, whether they have defaulted or whether you are sending an intent to litigate or an intent to arbitrate, you can get that whole package notarized. And now everything that you have notarized now is something that you can submit as evidence if you decide to go to court or go to distance.
Okay, so most importantly, whenever I send it, I need a legal paper trail that this
Yes.
thing has been sent.
Hmm.
Normally in a response time, how much time should I typically wait? Like 10, 15 days or maybe 30 days
So I would just say the rule of thumb is 30 days maximum.
maximum. Okay.
You know, uh, you can, after the first letter, you can push 10 days, 14 days. I'm a type of person, I'll use the whole 30 days. Because I mean, for some cases, sometimes you don't really care to rush it. I think a lot of times people want to rush it and unless you are in a situation where it's like, all right, bet, like I do want to knock this out, or I do know for sure that they're not going to have the evidence, then yeah, I'm gonna really push it. And I have the time and energy. But I'll push it 30 days so that so that I can have time to come up with my next response. It's more convenient to me. Um, the rule of thumb when you do send a letter, though, is 3 days for it to be sent, 3 days for them to review, and then another 3 days for them to send it back. So, minimum 10 days. If you decide, like in those later rounds, you want to push them 10 days. But once it hit that 11th day, you should already be prepared to send your next response.
Gotcha. So okay, so in that case, I'm gonna send my next response. That's gonna be if they don't do anything. That's basically I send them a notice of dishonor at that point because they haven't responded. Let's say in that scenario.
Yeah, if they didn't respond or they didn't send a sufficient response, insufficient response would be them completely you sending a letter with clear and conspicuous demands and instructions, and they only respond to one piece, or they don't, and they just send you a collection letter. That is not a response. That's a insufficient response. They're supposed to respond to it point for point. And if they don't, then it would be an insufficient response. And your response to that will be a fault and dishonor letter, letting them know about their faults and giving them a second opportunity to fix their faults.
And if they continue to ignore me, the next step would be then litigation, like small claims court, something like that.
Yes, it will be your default first, just like with a collection agency. Usually, they're sending about 3 letters before they start to say we're going to sue you or that you have defaulted.
Mm.
If you reach out to them 3 times, especially you take them through the process of my offer, you moving in honor first, you noticing the dishonor and giving them a second opportunity. If they still, by the second opportunity, still decide to not comply, given the fact that you put how they would violate you if they didn't comply in your first 2 letters, then your third letter is you saying, hey, look, I've reached out to you a couple of times, and this is a default notice, and you still haven't responded. So this is your last opportunity. It's not like this is not like the first 2 letters is more of giving them an opportunity to maybe question, maybe ask questions, give a rebuttal. But if we get to that third letter and you have defaulted, now the case is closed. The remedy has already been made. Okay. You either have acquiesced by your silence, you either agreed because by tacit assent, uh, you either violated me or participated in willful noncompliance. That is enough to have you default. And now is either you can do this now, okay? It's almost like your third opportunity. And I'm letting you know that if you don't adhere to my demands now, then I will take it to court. You haven't yet sent the intent to arbitrate or litigate just yet. This is that third letter notifying them of the default if they don't perform. Okay? So if after they have defaulted, and this is their third letter, notice, fault and dishonor, default. Your next letter could be notifying them of their, non-response. That's also a certificate of non-response. You could send an estoppel by acquiesce. All of those are really just like courtesies. But if you have these 3 letters of you clearly and conspicuously putting out your terms, you have now built evidence in a case. Obviously, you can send more letters. You can continue to challenge. It doesn't hurt to have more evidence of their dishonor and willful noncompliance. But once you get to those 3 letters, then you can dive into intent to arbitrate. Now, your intent to arbitrate or your intent to litigate is another setup, okay? Because that intent to arbitrate, most times they see that you are serious. Hey, damn. And he sent these 3 letters and he said he's going to take me to court. Dang. So what happens is that's when you'll start receiving the phone calls from their legal counsel, or that's when you'll start to receive the phone calls from whoever is going to represent them. And that's when they may try to negotiate or speak to you over the phone. But if you did this properly, you just stand on what you asked for previously. Hey, look, we won't even have to go to arbitration. Just provide what I asked you for, and then we won't have to go to court. Well, we can't provide it, so okay, bet what do you want to do? And that's what you will hope will happen after the intent to litigate. But if it doesn't, then That's when you file your claim after your intent to litigate. If they don't respond to your intent to litigate, let's just say you give them 10 to 15 days to respond. By that 14th to 15th day, if they haven't responded to your intent to litigate or even try to reach out for a settlement, then you file your case with small claims or arbitration.
And yeah, and that's kind of the point where I think we can stop, because the one thing that is critical is that we don't want anybody just to copy and paste someone else's method or just the little information that you heard here, because what you need to do is really research this and understand exactly what you're doing. The law is powerful, but only if you know how to stand in it. If you do not know, this information will not help you. Now, I'm aware that you have a school, and in that school, you provide resources and tools for people to learn this information. Can you tell me a little bit about that?
Okay. So if you want to learn more, and also be connected to me and a community of people that are actually doing this,
Mhm.
I have the Fund Yourself Academy. And in the Fund Yourself Academy, we really highlight the aspect of you being able to fund yourself, obviously, not only through like, credit or making money, but being able to keep some of your money, being able to not be stressed over money. And one of my main philosophies is being able to challenge debt collectors. So in my Fund Yourself Academy, not only do we talk about the legal merit behind the processes, but I have templates that is for educational purposes. I wouldn't implore anybody to go take these templates and just send them out right away, but they're good learning tools for you to learn and see how a letter is written out. What are some of the key things that I'm asking, and what puts them in a position where they will fail to provide the information or default. And I break down all of these letters, and they're available to you so that you can be able to review them at any point in time in the Fund Yourself Academy.
Cool. And I'm going to put a link for that in the description if we didn't already have a graphic of you showing exactly how to join this. Because if you guys want the information and to get the education, then I'm encouraging you, join the community. It's great to have access to all these different spaces so that you can learn from not just Nick, but others in the group. Now, a major question that I'm sure a lot of people have is, if this information is all legitimate, why isn't it taught, and why is this knowledge hidden?
Because it's just like anything else. I mean, we're here on YouTube, but nobody told us to get on YouTube. If we went to school, they would tell us to go get a job, and they built schools and universities to put people in a position to follow somebody, not become their own leader, become their own judge, to move. And I'll say this word, but not to like stir up the conspiracy, but they don't want you to be sovereign, if that makes sense. And sovereignty doesn't just start with your status correction, doesn't start with correcting your passport or having a trust and things like that. All of that does enhance that, but the sovereignty really starts with your mindset. And this information is out there. Just like a lot of information about business, getting on YouTube. People are creating a lot of success on YouTube. There's people who are creating a lot of success in the consumer law space, even credit, even business and e-com and all of that. But they aren't going to teach you how to become your own king and queen. They're not going to teach you how to get to their level, because they make more or benefit more from you when you don't know. They benefit more when you're not challenging them. Because think about it. It'd be a headache if everybody was sitting there attempting to discharge debt after years of them literally making billions of dollars off of this double dipping scenario that they have been doing. So not only does it benefit the banks, but I would just say that they are going hand in hand with the government, because when we are in a state of fear, panic, when we're in a state of when we're not flexible, when we're in a state of just when we're lost, we will just look at the first thing to follow. And the government is in our face all the time, throwing things at us. And again, I'm not a person that's here trying to be a conspiracy theorist and revolt against the government, but it's so that you can think outside the box. And they don't want you to think outside the box or critically think about your life. They want you to be more of a drone and think like them or think like how they want you to think. But
Yeah.
supreme law or the law of God, wherever religion that you believe in, uh, there is still a supreme law that even the governments have to follow, such as they can't take away our unalienable rights, and our unalienable rights talk about our liberties, our freedoms, and things in that nature that we don't know we give away when we contract to certain things. And this is why contract law is put in place so that we can overcome, invalid contracts and things of that nature. So, yeah, they just don't teach this because it benefits them more when we are in a
Ignorant.
state of a drone, per
Yeah.
se.
And it would shift the power. Um and people like to use the word conspiracy, but I think the conspiracy is to convince you that the system that you are just uh you're just operating in right now is just like because this isn't about paranoia, it's about control through omission. And a lot of people don't realize that, like, if you don't know your rights, you can't exercise them. You can't do anything in a system that you're unfamiliar with. And if you never realize that you've been giving away your power, then you're never going to be able to take it back. So it's it's funny that you mentioned like sovereignty, because I just did a video on how to become your own bank, but I did it through using Bitcoin, to where you can, if you have custody of your own Bitcoin, you can actually make your own transactions, send money. If you
Mm,
operate in several different countries, then you're actually able to avoid capital gains tax, or you don't just basically don't sell the asset, and you won't have a taxable event. And you're actually able to do all of this and become your own bank. And a lot of people don't know that that technology is readily available right now, as the government is putting out all of these laws in order to control this. And it's like, the crazy part is, if you can listen to what they're telling you, but look at what they're doing, and if you pay attention to what's going on, you it's I hate that we do that, where like I could show someone, like, look at what they just did, and then look at what they're telling you, and it doesn't match. Um, but that annoys me. One other thing that I remember you had mentioned, you mentioned the idea of the straw man. I don't know if we touched on that. Um, is that when you your name in all caps on a contract? Can you kind of explain that to like the average person and what that
okay,
is?
so excellent. So number one, I'll reference the book first. Meet Your Straw Man. It's only $5 on Amazon.
Mm-hmm.
You can get it digitally, or you can just Google it and you'll find it for free. Meetyourstrawman.pdf. Obviously, be moral and spend the $5. But so your all caps name. So when you are born, obviously you're living and breathing. And what happens is when you're born, you're immediately registered, your SSN is immediately registered, and your birth certificate, you sign off on a birth certificate. A lot of people don't know that that birth certificate is a title. So we all know a title is signifies ownership of something. Uh, so you get a SSN. Your SSN is attached to a estate, and the name on that estate or the estate's name is your all caps name. And you can even go back to the SKV Act, and how they was able to open up an estate in our name is because they made in the SKV Act, they pretty much said that if someone is dead, you can open up an estate in their name. Okay.
Mm-hmm.
And you will have ownership over that estate until somebody comes up and says, well, I'm not dead, I'll take ownership. So your straw man is an estate, but you are still your living, breathing person. Your straw man is, when you think of an estate, it's just like an LLC. It's just like a corporation. It's just like a business. It's technically dead. It's not a living or breathing thing. But then there's you, living and breathing, that has unalienable rights. But your dead, your straw man doesn't. Now your straw man is on every single piece of paper, not because that's you, but because that's how they pretty much like digitized you. That's how they made you a digital entity that they can then take away some of your rights. So again, just think of your straw man as a digital version of you that is connected to this trust account that we all talk about that's gives you the benefit to be able to acquire credit. Your strawman is also connected to show your debts and keep record of your debts, even when you're SSN. And people think that your SSN leads to a bank account that you can then use to pay your bills or to pay for certain things, but it's really there to keep record. Okay, because every time you incur debt, there is a record that pulls up on that SSN estate account that debt has been created. So that's why they kind of have that straw man in place so that they can be able to do some of the commercial operations or have you in that commercial jurisdiction. And the only way that you can kind of separate from that is by notifying them of your status. Obviously, you can do to correct your status and put it out there in the public by simply putting in an affidavit of truth or in your letter that you're a living, breathing person, man or woman, that is a representative of your straw man, should be enough to really correct that status, at least for that particular case. I don't know if I explained it good enough. That's why I say check out Meet Your
I,
Straw Man.
I
He'll
mean,
break it down.
I, I think, well, my biggest takeaway from that was, like, and everybody should kind of already know this, but this system, it runs on assumptions, and it's assuming that you won't know the difference between your legal entity and your natural self. And once you do, you start to be able to assert your rights, and you can demand clarity, and refusing to be held accountable for contracts made in bad faith, that we can start actually taking back some power. So again, I'm gonna put a link to that as well where they can cop that. I feel like we probably covered a lot. The last thing I wanted to get back to was the mindset, because there's clearly a mindset shift that needs to happen here. What do you say to people who maybe feel like overwhelmed or discouraged if this doesn't work instantly?
Um, that's a great question. Um, I think with anything that you do, whether it's business, content creation, consumer law, credit repair, whatever the case may be, business funding, it starts with your mindset towards it. And if you go in with the mindset that it's not going to work, then you shouldn't do it. If you go in with the mindset that hoping it would work, you shouldn't do it. You should come with the mindset of confidence. And the only way that you really build your confident mindset is by really reviewing the material you're on your own. Really staying in the environment and treating it, like you would treat anything else that you're confident in. You know, we'll probably know all the basketball teams, the starting point guards, the small forward, and all that.
Right.
And if you're talking to somebody about LeBron versus Jordan, whatever side you on, you are confident. And it's not because like, there's a hope. You genuinely feel like And that's what I'm talking about. The mindset to, okay, bet, let me become confident in the information. Confidence in the information is going to lead you to get the results that you want. So, and also at the same time, have long-term thinking. This is not something that's going to happen overnight. This is not something that you're going to do and it's just going to wipe away your responsibilities. Also, the mindset of feeling like this is taking away a responsibility. Because I also highlight to you that it may be harder to do this than actually to pay your debt,
Mm-hmm.
keeping it a buck, you know? And the point of me teaching this is for people who are backed into a corner, who feel like, okay, well, I can't pay it, right? And maybe in a position of potentially getting their car repossessed or default or whatever the case may be. This wouldn't be for a person who's already good, you know? Because it just take too much time and level of understanding and true dedication in order for you to get the remedy that you want. Now, after you do it, it'll become like plain and simple, but there are people at higher levels that hire attorneys to do this stuff for them. So you just have to be strategic and understand that this is not the only way to financial freedom. You have to develop a business. If you are going to discharge debt or stop paying on something, then you got to utilize that money to something that will benefit you and help you grow. So that you're not sitting here doing debt discharge and sending letters to every single company. Sometimes if you can make that money, then make that money. Like if your expenses literally are if you're in a place where you make 5 figures a month and your expenses are below that, there's nothing wrong with paying it. You don't gotta be the consumer law expert that discharges all your debt. You know what I mean? You
Oh,
don't have
facts.
to be that. A lot of people think that they have to, but you don't. Okay? If you can make money and pay your debt back, just do it. I know that inherently, oh, it's fraudulent things happening, but it's okay because it's about the energy exchange. You get what I'm saying? That's the true currency. That's the true wealth. What am I putting my energy into that is actually growing me? Am I putting my energy into myself or am I putting my energy at a job? Could I utilize my 8 hours much better towards myself, or am I going to utilize that 8 hours and give it to someone else? And people don't value their energy and time. So if you can find a way to make money utilizing less energy and less time, but also creating the same value for yourself, then pay your debts that way. But if you get backed into a corner, you'll have this in your back pocket, whether it's to communicate with a debt collector. And there's sometimes we get debts that are unknowing. Like, God willing, our parents, pass away, and now those debts fall onto us. Or we're in a marriage that we end up getting divorced and things get willed to me, and I have to have responsibility. This is when you can start to use these strategies to your benefit. Or when you get into higher levels of business, because
Yeah.
there are people that do this, and we're talking about contract law and challenging contracts at higher levels of business. So this is why Donald Trump is able to go bankrupt and multiple times and still be wealthy, because he understands that if he goes bankrupt, then that discharges the obligation for whatever business he went bankrupt. He didn't go bankrupt, his business did, but he
And
still had
people
multiple businesses.
and people think that bankruptcy is something that's actually bad. I'm like, oh no, it's just a tool. The wealthy use it. They just use it differently than when you use it. They use it very strategically. And this is like, I've been trying to say that for like a long time. I'm like, there's a point where, depending on what happens, I might use that. It just depends on exactly what I'm doing, probably for something really big. But um, if someone was to take this like very seriously and wanted to start learning, if they went to, like, let's say your catalog, what is the best place to begin?
The best place to begin would be um, if you've already watched all the YouTube videos. Obviously, that'll be the first place, YouTube.
Yeah.
And because on YouTube, I'll pretty much break it down in a way that anybody who is in the right frequency can be able to get that information and be able to apply it, you know, no matter where you're at. But if you're in the right frequency, I've had people reach out to me and say they're in the middle of a court case right now and they feel very confident about it. And I've only got a DM. Oh, I've seen your YouTube videos and I'm able to get this, that, and the third. I'm able to do this. Perfect, right? But after that, if you feel like you need more help, that's when you tap into the Fund Yourself Academy. The Fund Yourself Academy, you're able to tap in and really connect with me directly. Okay. And I also go live every single day, Monday through Friday, between 10 a.m. to 12 p.m. So I would just start there
And where is that,
and
on YouTube or Twitch? Or
Twitch.
okay,
Yeah.
I'm gonna put all of these links right in the description so you guys can just click on that and then go right to it. Especially if he's doing lives too, enjoying the school. I just don't feel like it's ever gonna be like this type of information. Literally, you've never seen any of this at all. You've never heard it. All you get is business credit card and business funding and no PG, blah blah. That's all y'all ever get. So when there's someone who's going to provide you with a lot of great information, especially that's being underutilized and no one else is providing it, you want to tap into all of his resources. And I'm definitely going to make sure as many people as possible can get there, and hopefully they can get this knowledge.
Absolutely. Absolutely.
And then, man, I appreciate you breaking this down. Because I know that this is beating this system is really, I'm not even sure if it's beating as much as you have to just figure out how it works and how to operate it, but understanding it enough to be able to actually manipulate it to your benefit is very difficult. And to explain something like this is even harder. So thank you so much. I appreciate that.
Absolutely, man. I mean, my goal is to take the emotion out of what out of business. I think that a lot of people still move with emotion in business instead of truth, you know. And that's a part of like our preconditioning, our programming. You know, we are so emotional that, we'll just like give in to certain things. But even if you decide I'm not going to do any debt discharge or whatever the case may be, but just having the discernment is important so that you can be able to maneuver and not be like in a panic if you fall into a situation like this. You more are prepared and ready. And if you have success, great. If you don't have success, okay, I didn't apply the law this way or I didn't provide any legal merit and I'm okay with that. I just lost the battle, but I'm ultimately learning and experiencing. So, yeah, that's what I'm all about, man. And I thank you for having me.
You're
Your
very
platform is
welcome.
huge. You've been running it up. I'm learning from you. You're an inspiration to me. I've watched content like yours for the last like 5 years and thought, okay, well, how can I get my foot in the door? And it started with Instagram, started with TikTok, then Instagram. And then I was like, all right, bet at the top of this year, let me go ahead and actually do it and take action on it instead of like, having imposter syndrome or thinking about it so much. Let me just go ahead and do it. And that's what I implore other people to do. You know, Fight against the things that you fear and, go full force with safety, of course, and win.
Definitely. What is the YouTube handle?
The YouTube handle is BizNick.
And what about Instagram?
Instagram is biz.nick. Twitch is
Biz.Nick.
biz_nick.
And then
That's
we
everything.
have and then we got the school as well. You guys can check that in the description. Make sure to subscribe, not to this, subscribe to Nick's channel, subscribe to his channel, comment discharge in the bottom if you want to know more information about this. We can make sure that he sends you something. He can send you some information. Comment discharge. All right. And we'll see you guys in the next video. And thank you so much for being here. Appreciate it.
Thank you. Thank you, Steven.